Hello, my name is attorney Masa Sam Foray, and I am founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to talk to you about all things related to Illinois family law. So today's question is, can custody judgments be modified? I have a custody order or a custody judgment. Can I get it modified? So the short answer is yes, you can under specific circumstances. Because generally speaking, once a court has entered an order, any order, particularly a custody judgment, or what we now call them in Illinois, an allocation of parental responsibilities judgment, those are not meant to be modified sort of happenstance. All right, it's something where the court has made a determination, oftentimes after lengthy litigation, and they have determined that that custody or allocation of parental responsibilities judgment is in the best interest of the children. Therefore, they don't want children's lives, especially once they've established that the order they have entered is most appropriate. They don't want children's lives overturned here and there just because of small changes. So let's talk about what you would need to do if you disagreed with the order of the court and with the resulting allocation of parental responsibilities judgment. So first of all, for any order in Illinois, you have a right, just as a matter of right, to file a motion to vacate or to modify within 30 days. It doesn't mean that the court is always going to grant it, but you can file what we call a motion to vacate or a motion to reconsider, asking the judge, him or herself, before whom you appeared, to change their mind. You can do that within 30 days, and even though it's not something that is automatically done, because you can imagine a judge that sat and presided over a custody trial is not necessarily going to be inclined to change their mind just because you ask. Nevertheless, you have the right to do so within 30 days. And obviously, many successful family law attorneys are skilled at getting motions to vacate or motions to reconsider granted, especially at this, motions to vacate and reconsider that are filed prior to 30 days after the entry of the order. If it's been more than 30 days after the entry of the order, so maybe this is an allocation of parental responsibilities judgment that was entered 6 months ago or a year ago, and for whatever reason, it's just not working out. You can still file a motion to vacate. Just know that the motion to vacate after 30 days has to be brought or filed under a different statute. There's a different number and there's a different section. And correspondingly, the burden is higher, meaning it's more difficult to bring a motion to vacate after it's been 30 days. So some of the things that you have to do in order to bring a motion to vacate and have standing, the ability to ask for a motion to vacate after 30 days, is that you would need to show the court, first of all, that it's been less than 2 years. In addition to that, that you were diligent. Also that there was a change in circumstances or new evidence rather that had appeared after the entry of the order, and had that evidence been available to the court when the court was making its ruling, the court might not have made the same ruling. So it's not just that you found out some new information, it's that you found out new information, you acted diligently, meaning you acted upon the new information as soon as practicable, and that had the court known about this new information, the court would have made a different decision. If it's been, more than 2 years, then just as a matter of right, you can file a motion to modify, a custody or allocation of parental responsibilities judgment. So now we've talked about 30 days, anywhere from 31 days up to 2 years, and now I'm talking about modifications after 2 years. After 2 years, if there's been a change in circumstances, then you can go on ahead and you can file the motion to modify. Again, modifications are based generally upon the best interests of the minor children. That's the underlying, sort of statute. That's 602.5 in the Illinois statutes that governs how a court will rule on any motion pertaining to children in the family law courts. And so after 2 years, if there's been a change in circumstances, and that change in circumstances may be that the other parent, who is the residential parent, now has changed jobs. Maybe they work overnights, such that instead of your children being with the biological parent from 7 p.m. until 7 a.m., they're with a non-family member, they're with a babysitter or a nanny. And therefore, because of that change in circumstances, you believe that it would be in your children's best interest for you to be the residential parent. So those are the kinds of things that you can do that don't rise to the level of, having to show the judge that there is new evidence. Okay, so after 2 years, you are more likely to win if you are able to show, again, that whatever change it is that you're requesting is in the best interest of the minor children. So there's one last category that I want to talk about, and that is, can you modify a parenting agreement if it's been less than 2 years and it's not due to some new evidence or some misapplication of the law, which is what you would need to show for a motion to vacate or to reconsider in some circumstances. You can do that. You can ask for modification of a custody or an APR judgment if there is serious harm or endangerment to the children. So if something occurred from the time of the entry of the allocation of parental responsibilities judgment that you believe now puts the children in great risk of harm and danger, then you can file a motion anytime. It could be prior to 2 years. It can certainly be after 2 years. It could be within 2 days. It could be within 2 weeks of the entry of the judgment. So again, courts are very, very interested, and in fact, they are mandated and they are tasked with making sure that they are acting in the best interest of minor children. So these time frames that I've given you in this video don't necessarily apply when we're talking about protecting minor children. That being said, especially if this is a custody or allocation judgment that was entered after lengthy litigation, and definitely if it was entered at the conclusion of a trial, courts do not want to reconsider and to change their minds. They don't want to enter orders just to have to turn around and vacate the orders. And so these are difficult cases to handle, but they are certainly winnable if you have an experienced family law attorney by your side. I hope that this has been helpful. I look forward to seeing you on the next video.